Hello everyone, welcome back to our channel. Let's continue our Samachar series, One Nation, One Election from Polity and Governance. Let's know what is One Nation, One Election. It is proposed system to conduct simultaneous elections for the Lok Sabha, House of the People and all Vidhan Sabhas, state legislative assemblies across India. This system aims to streamline election processes, holding them concurrently every 5 years to reduce the frequency of elections and the associated resource expenditure. Before knowing more about One Nation, One Election, let's see background of simultaneous elections in India. Simultaneous elections were initially conducted in India following independence, starting from the first general elections in 1952 and continuing through 1957, 1962 and 1967. But in 1971, this practice ended when the Lok Sabha elections were preponed due to political considerations under Prime Minister Indira Gandhi. Subsequently, the cycle for state elections diverged due to factors like early dissolutions, no confidence motion, and varied political instability. One Nation, One Election came into limelight again based on modern recommendations. The Law Commission of India 170th Report 1999 and the Parliamentary Standing Committee on Law and Justice 79th Report 2015 recommended One Nation, One Election to reduce costs, ensure administrative focus, and promote good governance. Several countries such as South Africa, Sweden, and Indonesia conduct simultaneous elections for their national and regional governments, demonstrating successful implementation of similar models. Let's look into the benefits on implementing One Nation, One Election. Good governance. One Nation, One Election can reduce campaign frequency, allowing governments to focus more on long-term governance rather than recurring electioneering. With fewer disruptions due to the Model Code of Conduct, governments would face less policy paralysis and can concentrate on continuous development initiatives. Resource conservation. Holding elections simultaneously would conserve substantial financial and logistical resources for both the Election Commission and the state governments, enabling funds to be reallocated towards developmental projects. Enhanced voter convenience. With One Nation, One Election, voters would need to participate in elections only once every 5 years, potentially improving voters' turnout and civic engagement. Curbing freebies and political spending. Frequent elections encourage populist measures and political spending to appeal to voters. One Nation, One Election can help mitigate this by reducing the incentives for short-term, politically motivated policies. Stability in governance. One Nation, One Election can provide a fixed-term government, reducing political instability and allowing parties to deliver on longer-term promises, improving accountability. What can be the challenges faced on implementing One Nation, One Election? Constitutional and legal challenges. Constitutional amendments are necessary, particularly in Article 83, 85, 172 and 324 to adjust terms and empower the Election Commission to conduct One Nation, One Election. It requires significant legal changes and potentially state ratification. Impact on federalism. One Nation, One Election centralizes election timelines, potentially reducing states' autonomy over elections and governance. Critics argue this undermines federal principles by restricting a state's ability to dissolve its assembly independently. Operational logistics. To implement One Nation, One Election, a vast quantity of EVMs, VVPATs, and polling personnel are necessary, posing a logistical challenge. The Election Commission would need a large-scale, organized procurement and deployment plan to accommodate concurrent elections. Political diversity concerns. National issues may overshadow local issues in state elections, disadvantaging regional parties. One Nation, One Election could empower large national parties while limiting the influence of smaller regional entities. Economic impact on informal sector. Frequent elections provide temporary employment to campaign workers, event organizers, and other service providers. One nation, one election could disrupt this informal economic cycle. Voter behavior and education. Critics argue that voters may conflate issues between state and national elections, affecting their judgment. Extensive voter education would be required to differentiate between state and national election issues. Let's get an idea about key recommendations by the high-level committee headed by former President Ramnath Kovind. Phased synchronization of elections, which means elections will be conducted in two phases. That is, in first phase, simultaneous Lok Sabha and state assembly elections will be conducted, whereas in the second phase, local body elections will be conducted within 100 days of the general elections. It proposed amendments to Article 82A, 83, 172 and the introduction of Article 324A to align terms of Parliament and state assemblies and allow continuity in the election cycle, even in the case of mid-term dissolution. Implementation of single electoral roll. A unified electoral roll for general and local elections to streamline process, requiring constitutional amendments to align state subjects. Logistical preparations. Election Commission of India will prepare a procurement plan for EVMs, personnel, and security resources in advance. A collaborative plan with state election commissions for municipal and panchayat elections will also be developed. Implementation group. Establish an implementation group to monitor and coordinate the One Nation, One Election process with all necessary stakeholders. Public Accounts Committee from Polity and Governance. We are discussing this because the Public Accounts Committee has recently taken its suo motu initiative to review the performance of regulatory bodies like the Securities and Exchange Board of India and the Telecom Regulatory Authority of India. So, let's get a quick overview of Public Accounts Committee. Public Accounts Committee is a committee of selected members of Parliament constituted by the Parliament of India. It audits the revenue and expenditure of the Government of India. It reviews CAG audit reports and ensures funds are used within the limits approved by the Parliament. And it also helps to ensure government's accountability and transparency. Whereas it has been established under the Government of India Act 1990 and reconstructed post 1950 under Indian Constitution. Now, coming to the membership of Public Accounts Committee, it consists of not more than 22 members, 15 from Lok Sabha and 7 from Rajya Sabha. Members are elected annually using proportional representation system, and chairman is chosen by the speakers, typically from the opposition since 1967, and ministers cannot be the members of this committee. Coming to the functions of Public Accounts Committee, it reviews government accounts, appropriation and expenditure as per the Parliament grants, and it also ensures funds are used legally, wisely and economically. And also, it examines financial irregularities, losses and improper expenditures. But it do have some limitations, like Public Accounts Committee recommendations are advisory and not binding. It does not have authority over policy decisions, and it cannot disallow government's expenditure. The National Human Rights Commission. We are discussing this topic as in recent news, human rights groups have raised concerns over the delay in the appointment of the chairperson for the National Human Rights Commission. Let's know about National Human Rights Commission. It is a statutory body established under the Protection of Human Rights Act 1993, and its main purpose is to protect and promote human rights in India by investigating violation and making recommendations. Let's see its composition. NHRC is composed of a chairman, full-time members and deemed members. A chairperson can be a retired Chief Justice of India or a Supreme Court judge. There are 5 full-time members, including a retired or serving judge of a Supreme Court, a retired or serving Chief Justice of a High Court, 3 experts in human rights, in which 1 must be a woman. And deemed members are heads of various national commissions like National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribes, National Commission for Women, National Commission for Protection of Child Rights, National Commission for Backward Classes, Chief Commissioner for Person with Disabilities. Coming to the appointment and tenure of National Human Rights Commission chairperson and members, they are appointed by President of India based on a committee's recommendations. This committee, consisting of Prime Minister, Speaker of the Lok Sabha, Minister of Home Affairs, Leader of the Opposition Lok Sabha, Leader of the Opposition Rajya Sabha, and Deputy Chairman Rajya Sabha. And their term will be 3 years or until the age of 70. Functions of National Human Rights Commission. It investigates complaints of human rights violation or negligence by public officials. It reviews human rights laws and treaties, suggests improvements. It also studies human rights issues like terrorism and recommends measures. And it visits jails to inspect living conditions and provides recommendations. Finally, it promotes human rights awareness and research. Coming to its powers, it has civil courts powers, where National Human Rights Commission can summon witnesses, examine evidences, and request documents. It can make compensation recommendations, where it suggests compensation for victims, and court interventions, which means it can approach higher courts to enforce human rights protection. Also, it has powers to take suo motu actions, that is, it has authority to act on human rights violation without a formal complaint. Now, let's look into its limitations. Though it gives recommendations, they are not binding. It lacks independent investigation machinery and cannot address older cases, especially over 1 year, which shows its limited investigative powers. Its jurisdiction is restricted because it cannot investigate violations by private entities or cases involving the armed forces. Also, it has enforcement issues, as no authority to penalize non-compliance with its recommendations. Finally, its funding and staffing issues, which also impacts its effectiveness. The Fact Check Unit. We are discussing this because in recent news, the Bombay High Court struck down the amended IT Rules 2023 that allowed the government to establish an fact check unit to monitor misinformation on social media about the central government. The Ministry of Electronics and IT had amended these rules in 2021 to empower the fact check unit to identify false information about the government on social media. Let's know the reason behind the strike down. Violation of rights. The Bombay High Court ruled that amended IT Rules 2023 setting up a government fact check unit violated Article 14, which is right to equality, Article 19 Clause 1 Subclause A, which is freedom of speech and expression, and Article 19 Clause 1 Subclause G, which is freedom to practice any profession. Vague terms, phrases such as fake, false, misleading were found too vague that they could be misused. It failed proportionality test as restrictions were found disproportionate and did not meet the standard of reasonable restrictions under Article 19 Clause 2. Chilling effect on freedom of speech. The threat of losing safe harbor status makes social media platform cautious. This caution can limit freedom of speech and expression. Safeguard concern. The center argued that any decisions made by the fact check unit could be challenged in court, but the court did not consider this option to be a sufficient protection or safeguard. Let's know about the fact check unit. It is established by the Press Information Bureau in November 2019 to combat fake news related to the government. Its function is to verify claims related to government policies, regulations, and announcements. Coming to its mechanism, users can submit their queries via WhatsApp, email, or through web portal. Relevant claims will be fact-checked through multiple layers of verification. Findings are posted as fact checks on social media. Fact check content will be categorized as fake, which means factually incorrect, misleading, which says presented to deceive, and true for factually accurate. About the Aparajita Women and Child Bill 2024. Recently in September, the Aparajita Women and Child West Bengal Criminal Laws Amendment Bill 2024 was passed by the West Bengal Legislative Assembly and forwarded to the President for approval. This bill introduces stringent measures against sexual crimes, specifically targeting cases involving women and children. Let's know briefly about Aparajita Bill. It aims to enhance the legal framework for dealing with sexual offences in West Bengal, which mandates severe penalties that includes death penalty in specific cases, faster investigations, and specialized legal processes. It also proposed amendments to existing laws like Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita, etc., to close legal gaps and ensure justice is delivered promptly. Coming to the key points of this bill, it mandates the death penalty if rape results in the victim's death or leaves them in a vegetative state. It also imposes a sentence of life imprisonment with no possibility of parole. This bill ensures faster investigations and speedy trials, with investigations required to be completed within 21 days and trials within 30 days. It proposes for the creation of a special task force called Aparajita Task Force, led by Deputy Superintendent of Police at the district level to ensure timely investigations and enforce the law effectively. This bill mandates the establishment of 52 special courts to exclusively handle sexual offences cases. It introduces harsher punishments, including life imprisonment and the death penalty for crimes committed against minors. This bill proposes amendments to central laws like Bharatiya Nyaya Sanhita, Protection of Children from Sexual Offences Act, etc., to enforce stricter punishments than those currently prescribed. And for repeat sexual offenders, this bill mandates life imprisonment or the death penalty depending on the severity of the case. This bill strengthens privacy protections for victims' identities, proposing 3 to 5 years of imprisonment for unauthorized disclosure. Publishing or printing court proceedings related to rape cases without authorization is punishable by 3 to 5 years of imprisonment and fines. Let us also see existing constitutional and legal safeguards for women. Constitutional safeguards like Article 14, which ensures right to equality, Article 15, Clause 3, which allows the states to make special provisions for women, and Article 21, which protects the right to life and personal liberty, and Article 23, which prohibits trafficking in human beings and forced labor. And coming to legal safeguards, Section 375 and 376 of Indian Penal Code defines rape and prescribes punishments, including life imprisonment in cases like child rape, gang rape that resulted in victim's death. Protection of Children from Sexual Offences Act 2012, which imposes stringent penalties, including the death penalty for aggravated sexual assault on children under 12. Criminal Laws Amendment Acts of 2013 and 2018 further expanded the definition of sexual crimes, introduced harsher punishments, and fast-track legal proceedings for quicker justice. Prevention of Sexual Harassment Act 2013 provides a legal framework to prevent and address workplace sexual harassment based on Vishaka guidelines issued by Supreme Court in 1997. The 23rd Law Commission of India. Recently, in September, the central government officially notified the 23rd Law Commission for a term of 3 years running from September 2024 to 31st August 2027. Let's dive into the history of the law commissions in India. Before independence, back in 1833, the Charter Act gave the Governor General of India the power to set up a law commission. The first law commission was created in 1834 and was chaired by Lord Macaulay. And guess what? They drafted the Indian Penal Code, a huge milestone. There were 4 law commissions before independence: 1834, 1853, 1861, and 1879. After independence, fast forward to 1955, when India set up its first law commission with M.C. Setalwal as its chairman, who was also the first Attorney General of India. Let's see the composition and tenure of 23rd Law Commission of India. It consists of a full-time chairperson, 4 full-time members including member secretary, ex-officio members consisting of secretary from Department of Legal Affairs and Legislative Department, part-time members not more than 5. Whereas the tenure will be 3 years from 1st September 2024 to 31st August 2027. Let's break down the 23rd Law Commission of India's terms of reference. Reviewing laws. They are going to check if our laws are in line with the Constitution principles, like TPSPs, preamble, and get rid of the ones that are outdated and no longer useful. Improving the judicial system. Here, the aim is to reduce delays in courts and make the whole system run smoother and faster. Protecting the marginalized. They will look into how globalization affects vulnerable groups like those facing food insecurity and unemployment and suggest ways to help them. Promoting gender equality. This one's about ensuring that laws are reformed to truly promote gender equality in both policy and practice. Simplifying central acts. They are going to make central laws clearer and easier to understand by removing any confusion or inconsistencies. Creating standard operating procedure. They will set up a standard procedure for regularly reviewing laws and making sure the legal language is simpler. Post enactment audits. Finally, they will access how effective social and economic laws once they are passed and make sure they are actually working. Prevention of Money Laundering Act. In recent news, the Supreme Court ruled that the Enforcement Directorate cannot violate an accused's right to silence by coercing self-incriminatory statements in a separate money laundering case while in judicial custody. Key highlights of the verdict. Right against self-incrimination. According to Article 20, Clause 3 of our Constitution, no person accused of any offences shall be compelled to be a witness against himself. So, ED cannot force self-incriminating statements from those in custody. Custodial limitations. When someone is in the custody, they don't have the freedom to make statements on their own. So, only statements made freely and without pressure can be used as evidence. Judicial permissions. Now, the ED must get approval from the court before recording any statements which help prevent forced or coercive practices. Overview of Prevention of Money Laundering Act 2002. Purpose is to prevent and combat money laundering, prosecute offenders, and confiscate illicit properties to ensure that illegal financial activities are stopped and criminals are held accountable. Obligations on entities. Under the Prevention of Money Laundering Act, banks, financial institutions, and intermediaries must verify client identities to ensure they know their customers, maintain records of transactions to track any suspicious or unusual activity, report suspicious transactions to the authorities, helping to detect and prevent money laundering. Money laundering definition, according to Section 3 of Prevention of Money Laundering Act, defines money laundering as any attempt, assistance, or involvement in processes connected to the proceeds of crimes to project it as untainted property. Offences under Prevention of Money Laundering Act. Part A covers serious offences like corruption, narcotics, wildlife crimes, cyber crimes, and intellectual property violations. Part B includes offences similar to Part A, but limited to cases exceeding Rs 1 crore. And Part C deals transnational crimes requiring international cooperations. Punishments under Section 4 of Prevention of Money Laundering Act. Offenders can face 3 to 7 years of rigorous imprisonment and fines. Concerns with Prevention of Money Laundering Act. Inclusion of minor and less serious offences. The Prevention of Money Laundering Act includes minor offences, which dilutes its focus on serious economic crimes, making it harder to effectively target major financial crimes. Equal punishments for serious and ordinary crimes. The law imposes similar penalties for both serious and minor offences, failing to distinguish between the gravity of the crimes, leading to disproportionate punishments. Broader definition of proceeds of crime. The vague and wide definition of proceeds of crime gives authorities too much discretion, increasing the risk of misuse and wrongful targeting. Strict bail conditions. It denies bail unless the accused proves innocence, which goes against the principles of presumption of innocence and deviates from fair trial rights upheld in Anglo-Saxon legal systems. Similarly, burden of proof on the accused. The law shifts the burden of proof to the accused, requiring them to establish their innocence, which undermines judicial fairness and goes against the principle of innocent until proven guilty. Federalism concerns. The Enforcement Directorate is empowered to investigate without needing state consent, which raises concerns about undermining the balance of power between the center and state, challenging the principles of federalism and basic structure doctrine of the Constitution. Deception detection test in India. Recently, the Central Bureau of Investigation carried out a second round of polygraph tests on 7 people connected to the rape and murder case of the doctor at Kolkata's RG Kar Medical College. This has led to discussion about the use, reliability, and legal limits of deception detection tests in criminal investigations. Let's know about deception detection tests. These tests are methods used to figure out if someone is lying during interrogations. They aim to identify changes in physiological or neural responses that may indicate dishonesty. There are three primary types of deception detection tests. First one is the polygraph test, also known as lie detector test. Measures physiological responses such as blood pressure, pulse rate, breathing, and skin conductivity. It operates on the assumptions that deception causes distinct changes in these physical signs. The next type is narcoanalysis, which involves the use of sodium pentothal, also known as truth serum, to induce a sedated state. This is believed to reduce a person's ability to consciously lie. However, its effectiveness is still debated and contested. And finally, brain mapping, which measures brainwave patterns in response to things like images or sounds. It assumes that when a person recognizes something familiar, their brain react in a unique way, which could help detect deception. Judicial perspectives. Before 2010, Indian courts allowed the use of deception detection tests without needing the accused consents, considering them as scientific alternatives to forceful interrogations methods. However, after 2010, Selvi was a state of Karnataka case. The Supreme Court of India ruled that lie detector test cannot be forced on anyone, as doing so would violate their fundamental rights. The court highlighted the potential for misuse and coercion in administering these tests. Key points from the ruling include consent required. Deception detection test can only be conducted with explicit voluntary consent, which must be recorded before a judicial magistrate. Guidelines compliance. The court required strict adherence to the National Human Rights Commission Guidelines 2000, which set ethical and procedural standards for conducting these tests. Access to legal counsel. Individuals must be given the opportunity to consult with lawyers before agreeing to undergo deception detection tests. Let's quickly know limitations of these tests. Inadmissibility in court. The result of these tests are not accepted as conclusive evidence in Indian courts. This is due to the concerns over the lack of scientific reliability, as physiological responses measured during these tests are not definitive indicators of deception. Inaccuracy of results. These tests can produce false positive, indicating deceptions when there is none, or false negative, indicating failure to detect deception. Factors like stress, anxiety, or emotional state can affect physiological responses, making the result unreliable. Constitutional rights violations. Forcing individuals to undergo these tests violates Article 20, Clause 3, protection against self incrimination. Article 21 ensures personal liberty and the right to privacy. Such coercion undermines the principles of a fair trial and violates individual autonomy. That concludes our episode. Now, let's take a moment to answer the upcoming questions in the comments. I hope you found this video insightful and gained some valuable knowledge. Try subscribing to our channel that will tag you with us. Thank you.